From the very beginning, lawyers in the United States death penalty defense community understood the power and the potential of the guidelines. I remember making many presentations at training seminars, and most good lawyers quickly accepted the guidelines and began using them. Some lawyers, of course, were unhappy because following the guidelines meant they had to work harder. But that was exactly the point. We wanted to create a common understanding of the very serious effort that was necessary. And we knew that raising the quality of representation would save more people from being sentenced to death. It took a little longer for judges to finally and fully accept the guidelines, and we still have more work to do. In the beginning, many judges didn't know what the ABA guidelines were, and they didn't think they mattered. But when defense lawyer after defense lawyer used the ABA guidelines in their cases and talked about them when they made their arguments, judges started paying attention. I also spent considerable time training judges about how the ABA guidelines could be useful to them. It was a time-consuming effort, and it always felt like it wasn't moving fast enough. But ultimately, our highest court, the United States Supreme Court, confirmed that the ABA guidelines described the professional standard of care for the defense of death penalty cases. I also worked with many individual state Supreme Courts and with state bar associations. The US has 50 states, of course, and each has their own laws and procedures. In many instances, state courts, bar associations, or even state legislatures agreed to implement the ABA guidelines into their laws. In Arizona, for example, a very active US death penalty state, lawyers must first show they have all the qualifications and skills required by the ABA guidelines. And they must agree to comply with the ABA guidelines before they will be permitted to represent a defendant facing death. It has now been 18 years since the ABA guidelines were created, and we can see the difference they've made. Nationally, there is a dramatically improved quality of legal representation in death penalty cases. And the guidelines have also influenced changes in the law in ways that have benefited hundreds of defendants and prisoners on death row. To understand why, it may be helpful to talk specifically about some of the most important guidelines. One of the most important concepts in the ABA guidelines is that of the defense team. This guideline recognizes how complicated and difficult death penalty cases are by requiring a team of people to participate in the defense effort. This guideline recognizes how complicated and difficult death cases are, and understanding that lawyers themselves don't have all the skills they need. We need people who have expertise, and especially an understanding of mental health issues. And we need people who are skilled at gathering information from people and records so that we can tell our clients' stories. We saw that the defense provided by a team of people were more robust, more complete, and more successful in avoiding the death penalty. Another guideline talked about the qualifications of counsel. This guideline makes clear that only lawyers who have received specialized training and can demonstrate the necessary skills should handle a death penalty case. This guideline was necessary because we saw too many inexperienced and unskilled lawyers appointed to handle death penalty cases, and they were simply unable to effectively represent their clients. The result was often wrongful conviction or wrongful death sentence. So this guideline was necessary to make clear that only specially qualified and trained lawyers should work on death penalty cases. A third guideline I want to tell you about is the guideline about investigating our cases. We learned through our mistakes the importance of conducting a thorough and independent investigation of every death penalty case. Our guideline lists many important areas of investigation that lawyers often overlooked. And it's important to emphasize the word independent when we talk about investigations. In the US and in some countries where I've trained, the court or the prosecutor has control over much of the evidence to be used against the defendant and may only provide the defense with a summary of what it is. This is not what we mean by investigation. The guidelines require us to aggressively challenge the government's case. That means we must actually see the evidence, not accept the prosecution's summary of it. We must test the evidence using our own experts. We must interview witnesses ourselves and visit the crime scene in person. We must independently determine what the facts are for ourselves. And I realize this may not be easy to do, but we have found that there are benefits when we ask and even when we demand what we need, even when the answer is no. First, it's important that our requests become part of the trial record. And second, when we make these requests and explain why we need access to information, it's an important way to educate our judges and change procedures. We also learned that when we conduct our own investigations and ask the hard questions, we almost always learn critical facts that help our clients avoid death sentences. Another important guideline talks about our relationships with our clients. It places importance on developing a relationship of trust with our clients. And this takes time and serious effort. This guideline tells defense lawyers that they need to communicate with their clients. They need to discuss developments in the case and obtain their agreement before making major decisions. And this obligation is also based on our ethical responsibilities as lawyers. But there are several good reasons for this guideline. First, we know that our clients are often our best source of information about a case. Second, it's important for our clients' mental health and well-being to have a relationship with their lawyers. And third, we must learn about our clients so we can tell their stories effectively. In the United States, we talk about our clients' life experiences in the sentencing phase of the trial, when we argue that they should not be sentenced to death. Many of our clients in the US have been abused or neglected or have suffered terrible trauma. And most of our clients will not easily talk about these difficult things in their past. But these are the details that often explain behavior or participation in criminal activity. So building a relationship of trusts helps us tell our clients' life stories well and supports our appeals for mercy, not a death sentence. Another guideline requires that death penalty lawyers receive specialized training every year. In the United States, the law is continuously changing. When cases are decided, especially at the United States Supreme Court, defense lawyers must learn new legal standards or procedures. And in the US, defense lawyers attend specialized training each year to discuss strategies for winning cases, changes in the law, and developments in science and medicine that can affect our clients. And they're also a wonderful opportunity for us to exchange ideas and seek advice for unusual problems. And finally, another important guideline is one that speaks to the importance of resources and funding. This guideline makes clear that the defense should be funded just as well as the prosecution is funded. Defense lawyers need to request necessary resources, even if they think their request will not be granted. This, again, will make sure that the record is complete and can be argued on appeal. And it's also another opportunity to educate our judges about the fact that adequate resources and funding are necessary for defense lawyers to do their jobs. In conclusion, use of the death penalty in the United States has become less frequent in recent years, and the number of executions has dropped dramatically. One of the biggest reasons for these changes is the increase in the quality of defense representation brought by the ABA guidelines. When good lawyers use the ABA guidelines, it becomes much more difficult for the government to secure a death sentence or to execute our clients. The ABA guidelines have helped us all become better defense lawyers. They've helped judges understand and support our work better. And the guidelines have helped influence changes in the law that have improved the administration of the death penalty. We certainly do not have all the answers, and we still have a lot of work to do in the United States. But we can now identify the ABA guidelines as one of our success stories.